Thank you, Councilman Solorio. This meeting we adjourned our council meeting on Tuesday till today, and it is approximately 1:59. Madam Clerk, we do have one member of the public that wishes to speak on the second reading, and this is Jigasha Payar, yes.
Is that better? All right, good afternoon, Mayor Pro Tem and council members. I am Jignesh Padiyar. I'm representing CB Labs as a cannabis. It is a cannabis testing lab in Santa Ana. And my question is whether the city of Santa Ana will be adopting the state's legislature on allowing cannabis labs to continue operating while they're in the process of getting accredited or in the pipeline of getting accredited, if that's part of the legislation, if the Santa Ana Council will be going into.
Can we take that? We'll answer that question afterwards. We'll take all your questions down.
Thank you. Now I'm going to move forward with this. This is a public hearing. Public hearing to approve the ordinance amendment to amend certain sections of Chapter 1821 of the Santa Ana Municipal Code, medical marijuana collectives, cooperatives, that was continued from the regular meeting on November 7th. And I'm going to move forward and ask our city attorney and city manager to move forward with the presentation.
Thank you, Madam Mayor Pro Tem. We have, as Mr. Jorge Garcia gets up here to get ready to lead the presentation, wanted to just give you a little bit of broad background on what we've been up to for the last couple of days. The item that was dealing with the criteria at the last council meeting generated a bunch of questions. I know I fielded a lot of questions from members of this council and also from members of the public. So the concerns seemed valid, so we decided to see how we can mitigate these. And so we've given a lot of thought and revamped our criteria, which we hope to present to you for discussion purposes today. We get clear direction, then we hope to bring back a more final draft for your approval, review and approval at the next meeting, November 21st. But before you today, we also have a couple of other ordinances. One of them would be a first reading, the other would be a second reading. But before we do that, we want to give a presentation so that we're all on the same page in terms of where we began and how we got here, and then what's before you.
Great. Thank you. Jorge?
Thank you, Mayor Pro Tem, members of the City Council. I'll be going through a brief background, and then we'll be walking through how we got here today and the actions that we're going to be requesting, as the City Manager indicated. So a little bit of background in the framework there. We started with the proliferation of illegal marijuana dispensaries in the city of Santa Ana, and an effort by the City Council and the community to really address that. The first legislative action that we saw was Measure CC qualified for the Santa Ana ballot, and that was back for the November election. So in order to prevent further proliferation and very little regulation as part of Measure CC, the City Council placed Measure BB on the ballot. That ballot prevailed, that ballot measure prevailed, and that is the current existing regulation that allows medical dispensaries to operate within the city. So it established the legal framework and the taxation for that process. And then the funds that were derived from that were used for code enforcement, the police department, and the city attorney's office. So the city was able to reduce the number of illegal dispensaries by over 80%. And currently 17 of the 20 permitted collectives or cooperatives are currently open. And then subsequent to that, in November of 2016, Prop 64 passed. So that was the Adult Use and Marijuana Act, the AUMA. So what exactly is the AUMA? The AUMA essentially allows for anyone over the age of 21 to possess and use cannabis, and it's age 18 if it's for medicinal cannabis. Also allowed for home cultivation for up to 6 mature cannabis plants for personal use. Some of the requirements that are listed within include that a local jurisdiction can adopt ordinances prohibiting or allowing commercial cannabis activities for medicinal, adult, or combined uses. So those include retail operations, warehousing or distribution, manufacturing or processing, cultivation, and then quality control testing. So embedded in that was also that on January 1st, 2018, which is just around the corner, is a deadline to comply or risk losing state grants for code enforcement. So this is the current structure in the Santa Ana Municipal Code that we have, and you'll often see them referred to by their chapter names.
Madam Mayor Pro Tem, I'd like to, I don't know how we want to do this, if we have questions along the way, or if to hold off to the end. I do have a question with regard to that last statement with regard to January 2018 deadline and the risk of losing state grants for code enforcement. Could you maybe go ahead and address?
Very quickly, just let them go over the report, and then we can just ask questions.
That'll work.
I'm writing the questions
And
down.
we'll write down the questions and we'll address them. So the current structure that we have in the municipal code, and part of it is the proposed for the second reading, is Chapter 18 was the original Measure BB items. So that applies to medicinal cannabis retail stores only. Chapter 21 is the taxes on the medicinal cannabis for retail stores. And Chapter 40 is the commercial cannabis. So an easy way to kind of remember that is 18 came before 40, Measure BB came before the adult use. So a little play there to help remember what sequence those came in. So Chapter 40 allows for the new commercial cannabis, and then it covers adult use, retail stores, and all other commercial cannabis activities as defined by the state. So what have we accomplished? As a city, we've shut down over 90 legal dispensaries across the city. We've hired new staff in code enforcement, the police department, and the city attorney's office. And we've generated revenue from gross receipt taxes. And we've also received recognition for being a leading edge ordinance and having an enforcement plan to follow. So how did we get here? The city had to respond, as I mentioned earlier, to the January 1st deadline. So the Planning and Building Department, as well as other agencies from the city, did extensive outreach with our various community groups, neighborhood associations, Chamber of Commerce, property owners, the cannabis industry, and other stakeholders. And the goal was really to be proactive leaders in an emerging industry to prevent the return of illegal operations. So how will the city respond? The first thing, of course, was the approach. We really had three options to consider, which was either to ban adult use, to regulate it, or to take no action. So based on the feedback, based on all the comments that we heard from those listening sessions, it was really the desire to regulate it, similar to how we regulated medical marijuana through Measure BB. So once it was determined that we would look at a regulation process, then it's how do you execute that? What was the technique? So really, in order to make it an allowable use and to regulate it, we could either do a ballot measure, as we did with Measure BB, but the timing wasn't quite right there. Given the timing and wanting to do it during a general election because of the taxation portion, really the best solution was to go through an ordinance, which is what we were recommending as part of Chapter 40. So once we have that, we know that similar to BB, there was cost that would be incurred, legal cost, enforcement cost, and then the desire from the city council and from the community to have a community benefit as part of this. So with that, we wanted to look at what are the cost recovery options that we have. And there's really three for consideration, which is taxation, a development agreement, or a fee agreement. A tax, of course, would have to go to the electorate. If it was in a general election, it's 50% plus one. If it's a special election, you're looking at 66%. So we wanted to adjust that and prevent that. Or we could look at a development agreement. Development agreement is generally associated with a property. And because these would be regulated more as a business activity and a business operation, really our option was to look at an in lieu fee agreement, which is what the staff was recommending. So the considerations, of course, with these would be the prevention, of course, of illegal operations occurring again, and to partner with the community and the cannabis industry to help with the prevention of that, to comply with AUMA, and to seek new sources of revenue for cost recovery. Once again, that's the enforcement, the community services, and the administrative costs. And those administrative costs would include the city attorney's office, city manager's office, code enforcement, the clerk's office. So we wanted to be able to have cost recovery so that the citizens of the city and the business owners at large aren't necessarily subsidizing the cost of this industry. So another important component was consistency with existing codes and plans. So a couple of the questions that we wanted to address were, for example, CEQA. So in this particular case, large cities across California are exempting ordinances from CEQA review, and this has been supported by recent state Supreme Court rulings, and then other cities have followed this pattern, such as San Diego, Los Angeles, Oakland, Richmond, and Napa. The general plan, we also wanted to ensure consistency with that. So new commercial cannabis activities in Chapter 40 are industrial in nature and are allowed only in industrial areas. So that is consistent with our general plan. In terms of the climate action plan, California Building Code does have one of the greenest in the nation and has strict caps on what is allowed in terms of emissions. Further, all new facilities that would be opened under Chapter 40 would be heavily scrutinized for building code compliance, and there's additional measures that are required under the AUMA, such as making sure that any waste that leaves the facility doesn't just go into regular trash containers, that there's other mitigating factors. So that is embedded as part of AUMA. And then, of course, the water conservation ordinance. So there's two components that we were really looking at there, and that's that all new facilities would be subject to both the state and local water conservation standards. The city council did adopt a water conservation ordinance, so when planning and building reviews any plans for those facilities, they would be ensuring compliance with that. As well as we wanted to add additional points in the merit system if the facility were to use recycled water. And that could either be through the use of purple pipe, so extending that system, or in the alternative if there was on-site water recycling systems. So that would be similar to how car washes are required to recycle their water on-site. If the industry were to use a similar system, there would be additional points that would be awarded. So today's actions, the three items that were continued to this adjourned meeting, the first two, staff is looking to get actions by the council today. The third, we wanted to have more of a discussion and get some additional feedback. So on the first action, which is to approve the first reading to amend chapters 18 and 21, that's on Measure BB, and then the taxation would be to ensure that there's consistency between SAMC and then the AUMA, and then to raise the tax from 5% to 6%. And then the second reading for Chapter 40 would be to establish the new commercial cannabis. We are recommending two modifications to what was submitted. Those modifications have been provided to you, and we do have a public copy that is available out front. And that would be to modify the cap on the adult use retail. So it previously was at 20. We are now recommending that that go to 30. All the other categories would stay at 20 with the exception of testing, and we would continue to maintain the distance requirements between retail uses. So that would not change. The other recommended change is that we would have exemptions for existing retail and testing operators in good standing from the merit-based criteria. And then the third item that we wanted to discuss today and receive feedback and make sure that as we're implementing the merit-based criteria is to get feedback. So we wanted to, rather than have action on that today, we wanted to present the revised and obtain feedback from the council. So the merit criteria. The merit criteria will be used to evaluate applications for new businesses. Criteria for retail establishments would include the control of the site, experience, operational standing, tax records, local hiring and community benefits experience and commitment. And then for those that are non-retail, we wanted to add two additional criteria for the merit system, which would be the economic impact and the sustainable business practices. So economic impact would include how many local on-site jobs would be created, things of that nature, or the valuation of the equipment that would be on site. So unsecured equipment that could go towards property valuation. And then the sustainable business practices would be their compliance with the city's approved climate action plan, with the recycling, and with any other sustainability plans or initiatives, whether they're state, regional, or local. So this is a summary. I know this may be a little bit difficult to read as we had this last minute, but I'll briefly walk over what that criteria is. Now, this is just for the retail side. As I mentioned, that there's two other components on the non-retail. The first is that the applicant would demonstrate control of the site, as we mentioned, and they would get up to 25 points. The second would be that the applicant demonstrates experience operating a permitted or licensed commercial cannabis activity within the United States. The third would be that the applicant demonstrates past experience in and commitment to local hiring. The fourth would be that the applicant, employees, volunteers, or any other person has no previous record of violating state or local laws related to workplace safety, wages and compensation, discrimination, drug-related felonies, misdemeanors, or union activity. The fifth would be that the applicant is currently in the Measure BB lottery waitlist. So if they were already on that wait list, they would be eligible for this. If you were not a part of the wait list, you would not receive those points. And then that last one, that's a typo. You'll have to forgive me for that. That should say number 6. And that would be that the applicant or the entity has no previous record of failing to make untimely reporting of their business license or other payments as required by entitlements. On the non-retail side, we have 7 areas. And some of those you will have previously seen, but the first adds a criteria for local control, and then there's additional points if they are further away from sensitive uses. So if the buffer, if beyond the existing buffer that's required, if they exceed it by 500 to 749 square feet, they'd receive 2 additional points. If they're even further than that, they could receive 3 additional points. There is a typo on that. It shouldn't say 20 and 22. It should say 15 and 17. So we'll make the correction on the final version. Once again, this is just for comment and review. We are not making a decision on this tonight. So we will receive any feedback that the council has and clean this up as well. The applicant must also demonstrate experience in operating a permitted facility as is previously required. You'll see number 4, the economic development. That's where we're talking about the job creation on site. So not how many jobs would they be creating outside of the city, but physically in the city boundary. And then to demonstrate the value of unsecured equipment. The other elements, as we mentioned, the climate action plan, water conservation, or addition to the purple pipe system. So there's some things that we can iron out in some of these details. But we wanted to present this to the council. And then the other 2 are listed in the retail criteria as well. So for both, the maximum points possible would be 100. In terms of the in lieu fee agreements, we wanted to discuss the in lieu fee agreement template. The in lieu fee acts similar to a development agreement, but it's not tied to the property, whereas a development agreement is more tied where a party owns or controls the property. A business may not necessarily own their property. So just like any other major retailer or regular retailer throughout the city may not necessarily own the property that their business sits on, this would not require that. So in order to work with the business, the in lieu fee agreement is a more appropriate mechanism to enter into a mutual benefit contract. Now this, I want to make sure the council is aware, this is something to get us through to the November 2018
just very quickly,
election.
Just as a clarification.
Sure.
Just
on
the
the
clarification
definition.
on the in lieu, on the term in lieu, and how I know with housing and a housing development, it's an in lieu fee. The developer's paying a fee in lieu of or in place of building on site.
It's completely
So,
different.
let's keep it really simple. It's just a terminology. It has no relation to land use. It's just,
So it's
this
not
is a
in
fee.
place of something else?
No, it's just because honestly, we would not be able to impose a tax until we go to the voters in November, and those that want to do business with us will agree to pay our tax even though it's not voter approved. We need to have a title for it. So it's basically a taxation agreement.
So it's in lieu of a tax.
Correct.
Currently, until November.
Right.
Correct.
Okay.
I'd like to refer to it as a fee for all the impacts.
And that's why and the title of it is an in lieu fee agreement. So they'd be remitting a fee based on the sales that they produce.
Thank
So
you.
the agreement does require local hiring and local sourcing, as well as community benefits commitments. And then all of the agreements that would be executed do need to be the same. So one provider wouldn't have a different agreement than the other provider. All of the agreements that would be executed would be on the template and would be the same. In terms of next steps, the actions today that staff is recommending is for what was 75E1, chapters 18 and 21, to hold the first reading. For 75E2, chapter 40, that would be to have the second reading with the modifications that were discussed. And then on November 21st, staff would be coming back with 4 items. The first is the revised merit criteria based on the discussion today. The second would be to authorize the city manager to sign in lieu agreements. That's the part of that third action. The next would be a resolution authorizing the city manager to send the state a letter of operational status, which would allow the existing providers an opportunity to open and start selling retail, adult use retail on January 1. And then the fourth would be a revised fee resolution. And that fee resolution would be to establish the application fee. Currently in our miscellaneous fee resolution that governs all of the fees that the city charges, there's a fee, but it says for medical marijuana. So we would need to strike that to just be for cannabis rather than just specifically for medical. So we'd be adjusting it to be the same fee, the same application process. And then if the actions are approved today, on December 10th, the ordinance would become effective. Future steps, of course, as mentioned, in middle of 2018, we would want to do all of the preparation for a general election. And what we would be doing there is really doing all of the cleanup, merging everything from chapters 18 into 40. So you'd have one section under a new chapter 40 for both medicinal as well as adult use and all the ancillary uses. You'd clean up the zoning ordinance and you'd establish the permanent taxation system. So all of that would occur as part of a potential ballot initiative for November 2018 at a general election. And then the deadline for that is August. We'd work with the clerk's office to make sure that we meet all the appropriate deadlines and back up to that date to provide the council with options for comment. And then, of course, we'd clean up the zoning, commercial cannabis, and then approve the business tax. And with that, I will turn it back over to the city manager.
Madam Mayor, that concludes our presentation.
The microphone.
Sure, Madam Mayor, that concludes our presentation.
And I can answer the 2 questions that were asked. Will testing be allowed? Yes, the provisions would allow. If the council were to adopt the proposed amendment that was placed before you this afternoon, the city manager would be authorized to allow any testing facility that was legally operating and under the operational standards. And then also, with respect to the question about the code enforcement grants, do you have a question about the other follow-up question? Okay. And then with respect to the question about the code enforcement grants, as part of the state legislation, they did make some money available to cities who were going to permit the operation, to permit code enforcement, to permit the adult use to apply for code enforcement grants. And so that is a deadline, but it's not the January 1st deadline doesn't mean you have to have these regulations. It's just that if you want to apply and you adopt the ordinance, then you'd be eligible for this kind of specialized grant funding.
And so that grant funding, that is, there is a deadline to have taken action before January 1 to allow for those
My understanding
operations.
is that you become eligible for that grant funding if you allow adult use. If you allow adult use, you become eligible to also get funding. But if you don't allow adult use, then you don't get the funding. You currently don't have the funding.
Are those the 2 questions?
You have more questions?
You got more?
Sorry, I do. I have several questions. I actually wrote down 7 from the presentation alone, so I can
Go
ask.
ahead, Councilman Benavides,
Okay.
go ahead. Yep.
So one you did address with regard to code enforcement. when it comes to revenue, so ultimately, I'll preface my personally, I think what I see as priorities, or at least personally, what I would like to see is that whatever action we do take, is that it's that what we implement is done well and makes sense for both the community with minimal impact, any of these uses, minimal impact to the community and maximum benefit to the community. And also that it's done well and makes sense for the business, right? So we're both regulating, but that we're also, if we're going to continue and to allow these businesses to operate and or to expand, that we do that well and that they're actually able to expand and that there are clear guidelines in place that they can do that well and responsibly, and it would be, again, beneficial, community beneficial to them. So that's just a comment and where I'm coming from when it comes to the follow-up questions. The cost currently to be able to administer and regulate or enforce, do we have understanding as to what that is, how much that is currently, and then ultimately what we anticipate that will both be the increase and in administration enforcement? What I'm ultimately trying to get to is what that surplus, if you will be, or that benefit to the community would potentially be with this expanded uses and permit. I don't know if we have a question, if we have an answer to that question right now, or if my question is clear. You know what? I'm going to list my questions, and some of these that way you can capture them. Some of these some of my colleagues might have as well, and then we can talk about how best to address them. The Luffy question you already answered as to defining that. Actually, my next question was addressed as well. The tax, raising the tax from 5% to 6%. I'm interested in knowing whether we have, how that compares to other municipalities, whether we have an analysis to ensure that, to indicate as to whether our current taxing model of 5%, is that proving fruitful and based on what we anticipated, and does it make sense to raise to 6%? Is it a win-win basically across the board? Again, going back to my initial question, is it something that will ultimately bring additional benefit to the community, yet at the same time allow for the businesses to be able to operate and ensure that they're able to expand, so that again, it's a win for them and a win for the community. We've also, my following question is the community benefit. We mentioned community benefit a few different times, and there is mention about local hire, and I'm curious if there are what other, quote, community benefits what other practices are going to fall as community benefit that we're going to be rating the applicants on, or the proposals on. And then my last question that I have at this point is whether the same regulation measures that currently are in place as a result of Measure BB would be placed on new applicants. So things such as on-site security, signage, hours of operation, testing, the auditing, and et cetera, if all of that would just be essentially placed on the expanded now adult use retail and any new applicants that are not currently within the 17. So those are the questions that I have at this point.
I have 4 questions for you, and I'll start with the first one, and if I missed any, please let me know. Regarding the tax rate, you talked about how did we know how much it was going to be enforcement, how much would it cost to enforce, how much would it not? On that, we can't be certain right now, but what we are certain is that after medicinal marijuana was legalized, we had a very large influx of illegal uses. And so we are anticipating at the beginning, at January 1st, of getting a large influx of adult uses. And then we expect to, but we have ramped up our program, and we are using a receivership program. Many of you may have seen the recent shutdown in the news. So we are really ramping up our enforcement program to do that. So we can't give you a good idea on the breakdown right now, but we will say that we do anticipate it to vary. In terms of the tax rate, how did we determine the tax rate? We did look at what other communities were doing, and it ranged from very low to almost zero, really, to 25%. We did not want to be prohibitive. We wanted to be competitive. Just like in selling a product, we felt like we wanted to be competitive and fair. And so in terms of the tax rate, raising the medicinal, we did move it from 5 to 6, and we do believe that revenues will help us continue to enforce on the medicinal uses. We talked about the cost of enforcement. Regarding community benefit, you had a question. As part of the application, each of the new uses will be required to submit what we call a community benefits plan. And in that, they will be required to outline and describe what they are going to be giving back to our community, whether it's in terms of reduced air quality impacts, social programs, whatever those things are above and beyond the taxation, not taxation, any in lieu fee agreements they have. That will be submitted and reviewed as part of the merit criteria, as part of their application process. And in terms of evaluating them, it will also be attached to their in lieu fee agreement. So it will be a contract between the city and the operator that they will have to do these things that are community benefits. Regarding your final question, are we requiring the same standards that we had for Measure BB? Yes, we tried to mimic that. We felt that ordinance had served us very well, and we tried to mimic our operational standards on the retail component of it. Of course, on the new components, it will be we'll be having to look at different things. Okay. So, if you have any other questions.
The last question I have right now is I know that going forward we don't know what the enforcement administration costs might be. It's perhaps a bit premature to date. However, do we have what our current enforcement administration costs are the actual and how they compare to what our actual revenue and what the nexus is?
No, but we can bring those. We will research that.
Okay, thank you.
And the only thing I could add to that is that we have staff cost in various departments. I mean, obviously, the police department has enforcement cost, code enforcement through planning, city attorney's office enforcement cost. Our enforcement costs, at least to this date, are in our budget with respect to the council approving an additional position, which we're hiring for. And some of our contractual services that we're now using for receiverships and whatnot. But I do think the council should understand that many of our costs that we've incurred to date have actually been in defending our regulations. So the highest cost that the city has incurred is because people were challenging Measure BB or challenging the lottery process. The haves and the have-nots, those that didn't get or those that wanted something different. Those costs were significant. They were almost $1 million. And I think to date now, our costs are mostly enforcement, where we're the ones initiating the action. So we would anticipate those types of costs, but I think this ordinance, we've really addressed some of the previous issues. But I would say that city attorney costs will range between $1 million and $1.5 million for enforcement, because I mean, we will constantly have illegal operators in the city, and we're going to have to continuously do this enforcement with them.
Councilman Tinajero?
Thank you, Mayor Pro Tem. I wanted to go to, let me go back a little. There were a few areas that I just had, I wanted some clarification. Let's start with today's action, the slide on today's action, where I just wanted to clarify where it says that the distance, we're talking about the distance. That 500 feet is the Measure BB distance for those that have a actual dispensary.
Yes, those that have an actual existing businesses, yes.
Manufacturers, manufacturing or grow would not be
No.
affected by that. Okay, so I just want to double check on that. Can we go to the merit criteria slide as well? And this is a question for our city attorney as well. So part of this industry is it's a new industry, and many of our operators have already agreed to pay above the poverty rate, much above. I believe it's almost like 200% above the poverty rate. Is there any criteria here that we could add that I know that state law already has, that if you work, if you have, I believe it's either 18 employees or 20 employees, I can't remember which, you have to unionize? Is there something that we can put in our criteria that would promote unionization or to make it compliant with state law? It's not like you're adding something new.
We had that in previous,
Yeah.
I'm going to continue with that,
okay.
but I'm asking that question right now on this slide.
Yes, I think we can do that. We could also incorporate within the, for example, within the community benefit,
Right.
if you wanted to give it points, if you said those people, but, do you want to absolutely require it like we've required prevailing wages, or we did like the PLA, our agreements?
I believe
Yeah.
it should be a part of that
Okay.
agreement. The reason for that, and the reason I bring that up,
Yeah.
is we live in a community where 50% of our residents do not own a car because they can't afford a car. And so anything we do, from affordable housing to a new job, a new corporation that's starting to get built within the city, it's in our best interest to assure that our people that are working in that industry have a livable wage, have medical benefits, and retirement. So that would be but that's just my opinion right now. There's 5 of us up here.
Okay,
And-
so you're talking about both local hire and labor. All right, thank you.
I think the labor compliance language is in the land use ordinance that's on second reading.
It is.
And we
It is on
adopted the
second
Long
reading.
Beach
But here's the
language. Yeah.
thing. I want it to be very, very clear.
Okay.
I don't want there to be any question about that. That's one. So let's go to retail merit criteria. On the retail side, applicants that are currently currently possess licenses and are actively servicing the community, and those who are on the wait list. Are people on the wait list, are they paying money to stay on the wait list?
Yes, they are.
Okay, that's what I wanted to know.
No.
Is that correct? They're not?
No.
Okay.
So they paid,
They
remember they
paid the
paid
money.
for the lottery? Remember that big charge we had
Yes,
for the
they
lottery?
paid a big fee.
Oh,
They paid a
okay.
fee.
And
to get
some
in.
of them are maintaining their property. Some of them are continuing to rent
Okay.
their property.
So,
Or hold the
but
property.
the current folks that already have licenses and are already in place, those folks would just be automatically, provided they're in good standing, automatically.
They will have to apply, and then, once they apply, we'll just make sure they're in good standing and they paid all their taxes, and then the director would issue a permit.
So they don't have to go through this?
They would be exempted from the merit-based criteria only because they are proven existing operators.
Got it.
And
Okay.
they have an RSP.
Got it. Okay. Can we go to the non-retail merit criteria, please?
Okay.
And as we ask these questions, I want staff to be very cognizant of the fact that each of us might have a different opinion, and at the end of the day, if we don't have a majority, it's just an opinion, because it can get dicey when a council member says, I want you to do this. So that unionization piece obviously has to be agreed to by the council as well. I do have a problem with the non-retail merit criteria number 1.
Let me go all the way.
And let me explain why I do have an issue with that. Is because it's one thing if we were in Iowa and there was this big plot of land and we had the opportunity to truly plan out where these businesses were going to take place. Our goal was to get them away from schools, residents, parks, and so forth. So we put them in our industrial zones. That was passed by 65.9%, supermajority on that. So to add a merit criteria here that gives you points because of where you are located, I think it's very difficult for me to swallow, because it was a race to the finish line. When BB came, when BB passed, it was a race to the finish line. People went out and fought and found sites wherever they could, and it was very difficult. And I think people are realizing that it's still difficult to find sites. So someone got lucky, and they found themselves in a position where now they can add 2 more points because they happened to find someone who decided to sell, or whatever the case may be. It's not like they planned on it. It's not that like they were being altruistic to fulfill a certain need. And so I want to bring that to my colleagues and say I think we might want to change that. But before we do, I want to hear your rationale.
Well, our rationale was that the further away they were from each other or from sensitive uses, the less concentration of impacts because of their adjacencies or proximity to one another, and their impacts on sensitive uses. So that was our criteria. That was our rationale from that.
And it's not a bad rationale. It's actually a good rationale. What I'm looking at is I don't want to constrict ourselves to that point, and give people that you might have someone that's that has more experience, but he happened or she happened to get a place where unfortunately that's all they could get, and then we don't get to bring them up to the top of the list because of that. So that's just something that I would like us to consider. If we go to item number 4, economic development, creation of jobs on site. I just need a little bit more clarification on what this means, it's a little...
And you're talking about pardon me, which one?
Economic development, creation of jobs on site, and demonstrates value of unsecured equipment for operation. Is it, obviously it has to be it's part of their job plan, I'm assuming, or their business plan?
Right. We wanted to know what kind of investment they were going to be making. So we were struggling with how do we determine whether this is somebody who's going to be doing state-of-the-art industry work, or if they're just going to be kind of hobbling along. And one of the ways we felt like we could measure it was through the value of the equipment that they were purchasing. So if they had a business plan that said that they were going to be investing $1.5 million in a machine that did blah, 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 that meant they were going to be like Amazon kind of level sophistication, or if they were going to have a hand truck. So we were trying to get a gauge for what they were, what level of operator they were going to be.
Okay.
If I may add.
Go ahead.
If I may add. We were trying to capture both sides of this economic development. One is large number of jobs. If they're going to do a lot of stuff manually, a lot of the activities manually, that they'd have a large number of staff to do that. If they were going to instead invest in automation, we wanted to be able to capture that to balance that equation, because probably have fewer employees, but then they'd have the investment in equipment which would generate property tax revenue for us. So we were trying to capture the economic development investment.
Okay. Thank you for that. And I wanted to just ask a question. It's not on the criteria sheet. I need to know if this is accurate or inaccurate. Any facility, whether it's a grow, whether it's manufacturing or a dispensary, do they have to be 1,000 feet away from a residence?
Yes, they do.
All 3?
All 3 of them, yes.
And that's what I wanted to clarify.
In fact, back to number 1 of the non-retail merit criteria, if they have to comply with that, and if they do, then they get 15 points for doing that. The additional distance requirements at most adds up to 5.
Right. So I'm going to conclude my questions for now. I would ask my colleagues if they would be willing to join me on the extra points for the measurement, and if they would also join me on the union component as well. And I'm finished with my questions. Thank you.
Questions to the left? Councilman Solorio?
Yeah, questions and comments. First, I do agree with those last set of suggestions that you made, Councilmember Tinajero. A few little mainly just thoughts. I do first want to thank the staff for this revised, recommendation set. I think it takes into account a lot of the feedback that you heard from the dais, from the industry, and from individual council members. So that is excellent. Some miscellaneous thoughts and ideas. First, on the timeline, I think I do see that there now is an understanding where we want to provide operational status to as many facilities as possible before January 1st. I did, though, it was ambiguous to me from what was presented if staff is recommending operational status only for current retail operations versus non-current retail operations or others. My thought is, aside from what the response might be, that other types of facilities like manufacturing, cultivation, R&D, those are occurring elsewhere right now. So if, January 2nd, we don't have any of those approved, these stores are still going to have product. But retail facilities is something that needs to be open and active on the ground, right away, so that they could be operable and so that the city could generate revenue. So I do understand and appreciate the staff is probably leaning towards just providing operational status letters for the current operators, but I would suggest and would have my colleagues think about that others that are also interested in retail may, or at least staff have the flexibility to vet that and possibly give operational status to those as well, especially if they have other California-based operations that we could vet as an example. So if there's a response on that.
Could you repeat the question again? I'm sorry, I didn't.
The question is, what's staff recommendation on who to provide operational status letters to prior to January 1st?
I think the state law, if you look at it, operational status means that you're up and operating and you have an operational status. And the only people in the city of Santa Ana that have operational status right now are medical marijuana dispensaries. And they have a regulatory safety permit that's going to mirror the regulatory safety permit for adult commercial uses. So we feel comfortable saying if you're an adult retail seller, you can have operational status in our city because you're going to look much like our medical marijuana, medical cannabis operators. And so I think the recommendation from staff is we could represent to the state that there's operational status. For us to be able to represent that we're going to have operational status on a brand new manufacturer that hasn't gone through a site review plan with the city or an RSP and we have no experience with, we may not feel as comfortable issuing that because we know nothing about them. They haven't even gotten through our merit-based criteria.
I definitely agree with the manufacturing and others. Again, I'm saying that with other retail operations that may have experiences elsewhere in the state and they can begin to identify land requirements, have an application reviewed, score well, and that can, because again, the product is there, have the product available, they really, but part of it is the definition, and I know that's the definition.
All those things for that new person. So for us to reasonably be able to do that after this ordinance becomes effective on the 11th, I believe, is what
December.
We're looking at,
we literally between December 11th and January 1st would have to do everything in terms of, even though they might have experience in Oregon or Colorado, we have to do a background check. We would never get the background checks done. We just would.
Well, I do appreciate, though, at least you see, though, the need to have operational status letters for existing ones prior to January 1st, so that's excellent. I think one of the things that still is ambiguous really is what does the state mean by operational status? And so maybe as the state continues to define what that is, or if they're exempt, or if there are written versions of that, maybe share it with us, because it could mean different things. And I think the other assumption that we're all making, even with comments like some of the ones that were just made, is that we're going to get 5,000 applications, right? It could be that you only get really one extra, retail dispensary application before January 1st, and so to do a vetting of just one application obviously might be doable, or It's another thing to require staff to give them versus giving staff the flexibility too, so that in the event that things are going smoothly, you don't get many applications, and if there is somebody that can literally buy the product, hire the staff, so that January 1st they could start selling, I mean, that's pretty operational. But again, that gets back to what the state's definition is.
In our existing ordinance, through the process, we have a process that at the very tightest would have to be able to turn around 1 month in terms of the application, and that is by ordinance, and that was the one that came before you at first reading. And so that would not get it, that would take us past that January 1st deadline. In response to your proposition that we would just have one, we had 679 applications for medicinal marijuana when it came through.
But a lot of those were repeat. I mean, some folks, as you know, submitted
yes, but
multiple.
in terms of staff processing, 679 is a substantial number. And
I agree. I just wanted to raise those questions and issues, but I think on the operational status letter, let's get down the road clarification.
Yes, but we have looked at ways to reduce the time frame and are trying to figure out how to move forward with it as quickly and as expeditiously as possible.
Excellent. Our city manager wanted to add to that?
All I wanted to just assure the council is that we would be incentivized to try to process and get these folks over to operational status. With the that's why one of the recommendations is to go from 23 to 30 for retail, to raise the cap to 30, because we want to allow for new vendors to have the chance to come in and compete. But if in the case where we have 17 existing, for example, 17 existing operators who would be given local preference, then that shortens the number of opportunities for new folks. And if we have, say, 50 or 100 applicants, we only can award the top 13, so we're going to have to go through a vetting process. And so realistically, we don't believe we can get to January 1st. We just don't see that, but we wanted to make sure that if we lumped our existing operators in that same process, then nobody would be ready. And that's why we came up with the recommendation of local preference, at least those folks who are already set up, and it's very easy for them to also sell cannabis for recreational use or adult use. That was our easy win. The other ones, we don't see process-wise how we can do that, but we're going to, of course, process it as quickly as we can.
Just continue to look at that. Again, it's one thing to give you flexibility versus you being mandated to do it. So just a thought. On the overall discussion of merit criteria, as I was looking at a lot of the criteria, particularly the earlier versions, but even this, I think some of those almost should be requirements rather than things that we evaluate them on. So, for example, some of the prior things in earlier versions were to have a security plan. Well, they all should. Plans to prevent, the usage and sales to minors. They all should. The 1,000-foot requirement, and I would just leave it at that. Just 1,000-foot requirement. Leave that there. And even things like maybe the local hire program. That may be just a requirement, just the way we have with our citywide project labor agreement. It could be, you have, 30% as a goal, and they just, commit to doing that. Obviously, the 500-foot buffer from other cannabis businesses. Other possible good standing items to give points might be, obviously, our local ones, but if there are other dispensaries in California that are in good standing, I think that matters. And I think that kind of is embedded in the new one. And then another one of note that I thought would be interesting is Santa Ana businesses and residents that may submit an application, right? Because oftentimes we see folks from out of the city, out of the county, or out of the state that come and invest, a bunch of money, as opposed to, again, giving preferences to our own, really our residents in our existing businesses. And I think there might be something there.
On that, I believe I can also support that.
Okay.
Yeah, okay.
Very good. And then staff is absolutely right on. I think, when we look at, particularly on the manufacturing side, particularly if it's merit-based, who to give something to, really if they have a commitment to create more jobs and more equipment, that's preferable than, a license to an outlet that's going to have one worker, and one, computer or something. So that I think is very meaningful. And then because of the multiple applications that we got through the lottery system, I would suggest we need to figure out a system so that there can only be one application for address, so that you don't have multiple ones, and maybe if some fall out for background checks or whatever, at that point somebody else could later on use that same address as a request.
I would support that too.
Yeah, but we don't want multiple ones all at once. One question that is a little bit ambiguous with respect to the even giving preference to our local business is, I think you're going to see that some of our local dispensaries want to do on-site cultivation or manufacturing, as an example. And again, since they're vetted, since they are in good standing, hopefully, etc., staff may want to consider giving operational status for on-site uses for those existing facilities.
So, Councilman, what we were thinking of doing for those uses is having them compete with other people for cultivation. So people who are interested in cultivation licenses, 20 that are available for cultivation, they would compete for that. For manufacturing, they would compete for that. And, so we're giving them local preference for sure on the retail, on the front end. And for the others, they're allowed to compete for any of the other
I understand that. And again, since you're going to have more time to work on this, I'm just throwing it out there as an idea, because I think what you're going to find too is some of the current dispensaries that we have bought larger size facilities that really already have the room for the manufacturing or the cultivation. And so really almost from a land use perspective, if you don't somehow help them achieve that, it creates an inefficiency, overall. So again, just food for thought, because I think there is something to that. And I know in our public safety committees, I think there was a lot of interest there. And I agree with Councilmember Tina here on anything else that speaks to distance is contrary to BB, but also, again, I would suggest that an entity that instead says they're going to hire more employees or more equipment is more preferential than an extra 500 feet from an already, pretty far away distance. With respect to community benefits, I would, for that, word it more along the lines of saying that we want good faith efforts for these businesses to join chambers, help schools, nonprofits, rather than requiring it or saying that they must have done it in the past. Because the reality is, that this industry is not fully accepted by everybody. So schools, as an example, quite frankly, may not want to have programs sponsored by Happy Cannabis.
Right.
And so to require it, I find it, difficult to put that commitment going forward or backward on a business.
Well, one of the things that perhaps in the first round we did have criteria, we did have points for that. On this round, we considered exactly what you just said.
Okay.
And so we're asking them to do this community benefits plan, for them to describe what they
would do. Well, good.
will
So
be
I think it's
doing,
moving in the
and
right
then
direction, yeah.
commit to it legally, contractually in their in lieu fee agreement. Yeah.
For example, we understand that maybe the school district or some little leagues may be, not receptive to that, but an option, if they want to support kid programs, maybe they could, donate to something, a program that the Parks and Rec Department of our city has.
Correct.
You see, and that's another way to get access to
Exactly, or to join the local chamber, or the Santa Ana Cannabis Association, or statewide. I agree. 3 more quick things, and then I'll conclude. On the purple pipes item, same thing there. Maybe things like that ought to be a requirement that they use best practices on water recycling, including purple pipes. But as many of us know, most of the city does not have a purple pipe system option, with the exception of
Those areas.
Some areas.
Yeah.
Not all of them, but not like near Harbor. Not like near Harbor, or it may not, or it still may be 3,000 feet away, and so the piping to get it from here to there can be expensive. But again, I'm just saying maybe that ought to be a requirement rather than a merit thing where we want them to do the best practices on really all the environmental components. And there too, I do not want to hurt past dispensaries that weren't asked to do that. Especially if we're going to, for example, on the manufacturer and others, have them compete, because if they really built out their infrastructure for some of these uses, last year, and now they're being judged to others that have new possible points based on that, I don't want to create that unfairness, so that's just something more to think about. And again, maybe another reason just to make it a requirement that they all ought to do that. In terms of where the money might go from the revenue, I know the staff for one item says for community services. I think at one of our recent council meetings, we had a lot of discussion about that, and I think there was really more the interest in youth. So at the very least, I would say maybe let's change that to youth and community services. But I know that was, in fact, part of the motion that we had done that was, quite frankly, just specific to youth services. And then finally, I know the staff is recommending an election to place some of these items in certain places of our charter or ordinances, etc. Why do we need to do that if we're really going to have this in lieu fee agreement and ordinances? What's the true? What's the real need to put this forward in election? Not that it would be bad, but obviously there's staff time, staff costs, etc., and doing that, communicating, etc.
It would be to perfect the arrangement and make it less susceptible to challenge. And we anticipate that what we're doing here, the ordinances that you have before you, is our best effort to date, but it's an evolving situation, and so we hope to have some cleanup that we can then bring forward, but mainly is to perfect that part of it.
Okay, and if that's the case, because we all agree we want something that is going to be as legally as strong as possible, but I think once we move these documents forwards and we begin implementing it, we're going to see what kinds of challenges, if any, they are. So we may find out that this actually, with all the good staff work and legal work, is real solid, that maybe we may not even need that, but at least now I understand the reason why staff is asking that.
In fact, in the ordinance for Chapter 40, it actually envisions that we would have perhaps a couple of chances to do this. I think the in lieu fee agreements are extendable for a couple of years at a time to coincide with the election cycle. So if at first we don't succeed, we can try again, and we can try again, and then we'll figure it out from there.
Got it. Thank you. Those are my points for now. Appreciate it.
Councilman Villegas.
Thank you, Mayor Pro Tem Martinez. See, under the benefits section in the in lieu agreement, Section C, again, coming back to the community benefit plan, I thought during the committee we had asked, or I had asked that instead, we specifically have money go towards prevention and education programs for the youth regarding drug awareness, drug education, and I don't see that here. All I see is, they're going to put forth some kind of plan, and like Council Member Solorio was saying, that some of these organizations out there in schools, they might not be receptive to receiving that. So I believe that money should be going to the city, and that we know where to put the money. Yes, please. Yes.
Can I respond to that quickly? I know you probably have a list of questions, but we're talking about two different things. The first thing is the revenues that are generated by these businesses through the in lieu tax fees, and those would be the things that we were talking about, monies to code enforcement programs and monies especially to the youth, which we had talked about at the subcommittee. And that would be up to your discretion through the budgetary process to decide how to allocate those revenues that are coming in. We want these uses we want the regulation of these uses to be funded by the revenues that they generated. Any additional revenues that they generate which will be for community benefit, can be allocated by you under your direction. We didn't address that in the ordinance. What we were asking for them to do above and beyond the taxes that they pay is to come up with this community benefits program so that we can figure out which businesses are going to be our best community partners.
And for example, we would have hoped that one of the vendors might decide to fund a youth, prevention and diversion program that maybe is run by the PD or by our Parks Department to do exactly that. We did not, we try to summarize this, but certainly we have the original input from the committee, and if they came to us and they said, what types of community programs is the city interested in, we would mention the ones that were mentioned in committee.
And it was actually at the council meeting.
I just want to make sure we lock something in and it's solid, because I don't want it to go sideways later on, and next thing I know that this thing goes away and we just concentrate on something else, and that's why I wanted to make sure a good amount goes to fund this specifically. Okay, and one question, I know we went over this a minute ago, I just want to be clear. So is there not a deadline for us to have something? I know that, I was told that January 1st, and, we need to have something, correct? So if we don't have anything, we have a ban in place anyway for the rest, right? Can you clarify that for me, Mr. City Manager?
If we can go back to that slide where we have the three graphics on the one page.
Oh.
Yes, how will we respond? So the approach, those are the three options, Councilmember. We have option number one, to ban.
Which we have in place, correct?
We do.
Okay.
Everything that's non-medicinal. The second option was to regulate, and the third option is no action. And I believe that if we ban, we are not eligible for grant funding.
For code enforcement grant funding, yes.
And so actually another question I have for my staff is, we know that if we regulate, we're eligible, but what about if we take no action? Are we eligible for grant funding in that case?
No, we are not. And in addition to that, we don't get to say where they're located. I mean, basically.
No, that's not true. That's not true.
Right.
I just want to make something I don't mean to disagree, but I think there is disagreement. The state law made it very clear that they were not going to usurp local land use and zoning control. That's what the state law said. It made it very clear. They are going to let you, as the council members, as the policymakers in the city, control land use. And if you decide that you don't want these land uses permitted, that's up to you. If you want to permit them, then that's up to you. But I just need to make that clear, because I do think that there's been some confusion about that. And you're not forced to do anything. It's a policy decision if you want to allow the commercial uses or not. And I think staff's done a very good job. If you want to allow commercial uses, I think they've done a very good job in identifying how you would do that. But I do believe that maybe someone, and I'm not sure who, might have represented that if you don't allow commercial uses, that you are going to lose your ability to regulate. And I think that was a misrepresentation.
Yeah,
so I don't think so. I know that was a misrepresentation.
I was led
and
to
I want to
believe
clarify
that. So I just want to clear, and I want to thank the staff for working really hard. This is a lot of work. This is still a little iffy, but I just wanted to clarify. So if we do allow the retail after with the current people that are operating right now, the other collectives, the other sections, they would still be banned, even though we can allow just the one retail. Is that
so I mean,
correct?
I think the city manager did a good job of giving you your options. But what I think what your options look like, there's actually multiple options, because a city, for example, has the ability to completely ban. The city has the ability to have medical and ban everything else. A city has the ability to allow medical and adult retail and ban everything else. A city has the ability to have medical, retail, and cultivation and ban everything else. So you see there's like all those categories, and you have that complete control.
I just don't want to be rushed, but I will say for the record, the two council members here that were given their input, I support that. But just want to take it slow and make sure that everything's done correctly, because this is a biggie here. And I want to make sure we get it right. That's all I have at this moment. Thank you.
Thank you, Councilman Villegas. So now it's my turn. So hopefully staff's all prepared, because I have a lot of questions, and I'm not sure I'll be able to answer everything, and so hopefully council members will be able to make a motion so that we can move quickly. But first and foremost, let me just start by thanking our staff for making the changes that they made in a couple of days. And I met with our city manager and our city attorney on Monday, and I wasn't so very nice, and certainly it was our city manager's really first meeting coming in on Tuesday. But as I mentioned to him, I'm an equal opportunity that I hold everyone accountable, and it's important when we have a policy decision, specifically a land use decision that is very major coming to our city, that we need to do our due diligence. It's important. And we owe it to the residents of this community. We don't owe it to the operators of the cannabis industry that's here or the future. We owe it to the residents of this community to do what's right by them. And so I was elected to do that, and so I raised a lot of questions. I want to thank you for speaking them and making sure that we're consistent with our general plan, that we're consistent with our climate action plan, that we're consistent with our water conservation plan. Because when we start to look at, everything, and I can look at the different components, and I don't think I'm going to have enough time because I know Councilman Benavides needs to leave by 3:30. But I'm just going to try to synthesize and put it all together here very quickly, and ask just some very specific questions, in particular the in lieu, because I think this is important, and the decisions that we make here. In lieu fees are temporary, and I want this to be confirmed because of Proposition 218. A city is not allowed to tax without going to the voters. Is that a true statement? Yes or no? It is a true statement. So our in lieu fees, what we're doing here, is this temporary, and why you're asking for us to go to the voters? Yes or no?
Is it temporary? Yes, I think it's a temporary interim fix if you want to collect revenue from new uses by contract.
Yes, Councilman.
So just to clarify then, because there was a question one of my colleagues made, can the in lieu fee, does it have to be temporary, or can we say...
It does not have to be temporary.
Does not.
You could
Okay.
make the policy decision to just continue to do this by contract.
Okay.
But the proposed ordinance envisions it being
Right,
temporary.
right, but right. So that is what's being proposed, is that it goes to the voters to become permanent, or to become, I guess, voter-approved, a voter-approved tax. However, absent that, it can remain an in lieu fee in perpetuity as long as this ordinance stands, and we can still collect.
Right. I think what staff
right now-
is saying, let's say, for example, if I'm misconstruing it, you have someone that's operating, and you do the in lieu agreement, and you don't go to the voters, at some point, they can say, wait a minute, I'm not going to pay that tax, and then sue the city. So what our staff is trying to do is go ahead and provide the in lieu now to get everybody moving before January 1st, but then take it back to the voters to solidify the tax. Let the voters vote on that. Is that correct? See,
But that's Prop 218 law. That's just Prop 218 law. Cities are mandated, and I think you all know I've become an expert in Prop 218. We have other issues as it pertains, and you certainly don't want to go down this route on this issue, because there will be litigation if some of these operators who want to come and do business here don't get those licenses. We're literally opening ourselves to plenty of lawsuits just based on this issue alone. And so I think we need to make that very clear, and that's the last thing that we want to do. With that being said, the next thing that, as we look at retail, and I'll be the first to tell you that certainly I also want to get a response from our city attorney as it pertains to, what the state is doing. They are giving a temporary permit for 120 days. Is that a true statement, yes or no?
Yes, that is my understanding, is that they're not ready to issue full permanent permits, so they're going to give temporary permits
And if
for
I may-
120 days.
Would the city of Santa Ana be able to give a temporary permit with retail? And I say temporary, and just going back to the issues of Prop 218, until we go to the voters and the voters vote on this. We need to protect ourselves. And so I want to make sure that I believe it's in the best interest, as the state is doing it temporarily, we should also be doing the same thing until we go to the voters in November. Is that a possibility, yes or no?
That is how it's structured.
That is how it's structured.
Right now, it's structured so that they are required to operate in the city with an in-lieu fee agreement. The in-lieu fee agreements have a time deadline that meets until December 2018.
So is that
Then
for a
it
total of
can
12
be-
months?
Pardon me.
Is that
excuse me.
is that 12 months?
Is that, actually, it goes to, the first one is January 2020, and then it could be renewed again to January 2022. Both times are scheduled so that they are structured so that there is a certain amount of certainty for the developer, but they also coincide with the ability for us to hold general elections in 2018 and again in November 2018 and again in November 2020. So, and bring that to the voters. So that's the way the in-lieu fee agreements are structured.
So I wasn't sure whether your question was about a temporary operating permit or a temporary tax.
So
think
this,
you
I
answered
understand that we have this is a temporary tax until we go to the voters. I am asking about maybe in concurrence with the temporary permit until we become, whole per se. I'm just trying to protect the city.
Right.
And so I think we have temporary and temporary lieu and also temporary operating permit until we're able to go to the voters and making sure
that they can't operate without an active in lieu fee agreement. That's a requirement of the ordinance.
Right, but I think she's asking something else. So the changes in the ordinance that we've proposed would allow us to issue a regulatory safety permit to all of our existing medical cannabis operators. And if we issue the regulatory safety permit, that permit's good forever. I think the question is, could we limit the the RSP to 120 days so it matches the state? So that way, if the state has regulations, I think that's.
We are not issuing them a new regulatory safety permit for the adult use. What we're doing is we're saying that we're giving them a letter to the state that says they have standard occupancies, they've met our requirements for that, and it is good on a temporary basis consistent with the licensing.
So we did a lot of this really quickly, but actually the language that we drafted earlier today does give them the RSP because we weren't going to make them go through the merit-based system.
Yes.
So I think that's where a little bit, and then we did this really quickly.
And we can.
So that's the question, and that's really a policy decision for the city council.
You.
Yeah.
Mm-hmm. Yeah.
So I just wanted to put that out there because I think it's important for you all to realize that. And then my other questions, and I'll be very clear because I do have a lot of questions and I'm looking at time. But I think the revenue and the taxation component is important, and obviously there's a little bit of confusion in what is being presented to us. But I will say that on some of the criteria that I think we should be including that would be important for our residents and the quality of life is one that I do support the delivery. I think is we're moving in the right direction. I think it's important. But I would also just hope that as we look at our climate action plan and wanting to reduce greenhouse gas emissions, and I want to just state this point in fact as well, that we're the only kind of game in town here in Orange County, right? And we have a lot of folks come into certain dispensaries, and certainly they're going to be coming more here to this city. But, now that if we do support and moving forward towards delivery, we have other opportunities for folks to either take it to them or order online, however they so do it. One thing that if they are going to be using vehicles, figure out whatever possibly way that we go as green as we possibly can. I think it's important for us, I think a lot of us up here talk about the environment, wanting to make sure that we are clean and green. We need to definitely keep that in mind because if we are going to be doing lots of deliveries, that's we have to with the state mandates, with the SB 375 and the SES, which is the Sustainable Community Strategy, we have to reduce our greenhouse gas emissions. And now the ARB is telling us that our region has to go up to 21%, which that's over, we don't ever believe that we're going to be able to achieve it. So SCAG's trying to fight to do 19%, and that's still a really high number to meet the needs of the SES. And so knowing this industry is coming in, that could have an impact. And so we have to be cognizant, specifically here in Orange County, when Santa Ana typically leads the way with our SES. The other thing that I would also like to speak of on the criteria is that our code enforcement has a program, and I think it's with, I don't know what it's, PREP, is it the PREP program through Apartment where they do annual inspections? Okay. I believe that we need to have a 6-month inspection if we're going to be moving towards all of this, giving staff the amount of, specifically code enforcement, to go out there and inspect, every 6 months and making sure that we're doing our job. We're already investing a lot of money in law enforcement, in our attorneys, and I think we need to have a program in place that would help us move towards making sure that everyone is in compliance. It's great to put all these requirements, but the reality is this, ladies and gentlemen, we only have 16 code enforcement officers. They have a lot of other work beyond just this industry here. They don't have enough people, and so when we're asking for all these requirements, we need to give them the resources, and we should be mirroring the same program. Yes?
I just want to mention real quick for the council, I know we have councilmen who need to leave, but remember this. There can be fees that are charged to apply for something, like a permit. The RSP, it's going to cost city staff time, 15 hours, and there's a fee. It might be $1,500, $2,000. There's a thing called a regulatory fee. A regulatory fee, like PREP, is when you look at all the staff time it takes, enforcement, city attorney, code enforcement, how much time does it take for us to regulate this industry? We can actually impose a regulatory fee with no Prop 218 requirement.
Mm-hmm. Right.
And then third, you can have the tax, which is just, we get to collect this money from you because it's a tax, because voters approved it. My understanding is we will have a fee, and we're proposing a tax, and there is an opportunity to look at the regulatory program.
Yes, that could be something we would bring back to you at a later date. But again, we're not talking about a tax here. We're talking about a contractual agreement between the city and a business.
Agreed. So I got like 30 more questions. I'm not going to ask them all, but I will, just based on the conversation that was being had here as it pertains to this about the community plan and the funds that certain schools or whatever have you may not accept it because they don't want to accept this money from this industry. The city also has the ability to create a special fund. Right. We have many special funds. You create a special fund, and we can put a cap. We can say, hey, we want all these dispensaries to put, $150,000. You divide it, but that's what's coming into this special fund, and we get to do what we want to do. Bring it to the council to then apply it to what Councilman Benavides has mentioned, what Councilman Villegas has mentioned as well. And so again, you could go that route in doing a special fund, and that's something that I believe is the right direction versus asking the industry to put a plan together and figure out how they're going to be able to spend the money. And so we have the power to do that. I think it's something that we should designate and do here today. And then just lastly, from an equity component as well, and I do agree with Councilman Solorio that we should be able to allow Santa Ana residents, if they do want to compete and they are here, that they should be eligible to get into this business as well. I know that the city of Oakland and Los Angeles, in particular Oakland, has moved forward with an equity permit, making sure as it pertains to disparities in the cannabis industry, in particular to the victims, having those opportunities. And so I would like for us to look more into that because I am in agreement that we need to make sure that there is an equitable process, that there is a community benefit here with here in Santa Ana with our residents. And then just finally, I do have this last comment, and it's more of a process Is it, could I ask, because this is a land use decision, why didn't this go to the Planning Commission?
It was considered more of a business license regulation a process than a planning commission process. All of the uses within this industry, manufacturing, distribution, warehousing, are allowed within and including via Measure BB, the retail component of cannabis sales, are already allowed during our industry. And depending on the type of facility that you have, say in manufacturing, depending on the type of manufacturing process you would go to, you might it may be allowed by right or require a CUP. So for that reason, we did not take it to the Planning Commission as a land use issue.
Great. Thank you.
I have a question for the City Council right now, if that's appropriate. I'm hearing only one policy issue that we have on the ordinance. The rest of the comments that I heard from you were comments related to our evaluation criteria and things that we will be bringing back to you. And that comment had to do with your comment, Mayor Pro Tem, regarding the length of the RSP, whether or not to have that RSP be just extended permanently or have it be run concurrent with the temporary license of the state. And I guess that's the question that we need to address before we take action.
That's a big policy issue, so, there haven't been any motions on the floor. I know the first item, which is pretty much is making sure that we're making amendments so that Measure BB is in concurrence with the adult use. Is that a correct statement? Yes or no? Yes, right? So
E1, we want to do this right. So E1 is just to simply clean up Chapter 18 definitions and Chapter 21 business license.
And that's the business license, and that will be raising the business license tax on medicinal marijuana.
No, we do need to hurry because I know Councilmember.
Yes, so I'll make a motion to, go ahead, Councilman.
I do have a question with regard to E1. In that one, there is that's where we're addressing the tax rate, right? And we're looking at going from 5 to 6%, anticipating that the additional percent would generate about $500,000 in annual revenue, and where we've identified a third to go to several different funds, whether it be general fund, enforcement, administration, or youth services, right? So we're going to change there. The question that I have is, when we discussed this previously, and my question earlier, to try to get a handle on what our current cost administration, I know at the beginning there was more of an excess because we were dealing with all of the rogue unlicensed dispensaries, and there was a fair amount of resources spent there. With that having come down significantly as we go forward, I think we have a new base. So my question, ultimately, bottom line is, the intent, at least my intent, was that overall, the revenue coming in overall, that we would have a larger sum, a third of that third breakdown. The way it's described here, it's only on the additional 1%. If administration and enforcement is if 2/3 of the overall revenue, which I believe it should, the 2/3 of the overall revenue that will be coming in would cover administration enforcement, then there should be an overall third that would be able to be used for programs for the community, programs for our youth. That's the overall intent. So there is some type of
So it's not the increment, not the 500.
It's not the increment.
It's for the total
increment.
So if you make the motion in that manner, then that would make sense.
To explain something, it's a great policy question, but the reason here is that your monies for all the revenue have already been budgeted. Okay, so for the existing budget already looks at the revenue. So really, this staff report is about the increment. That means the over and above, which is the additional 300 to 500,000 that they believe it will generate. Now, when you come into your next budget cycle, you can ask staff, how much revenue have we gotten from the Measure BB? How much did we get from the new adult retail? And you can start to program that money however you want to.
So, and we could also address it by saying in the language that going forward would be this new increment, because that has not been budgeted, and looking forward prospectively, then the balance or the general, basically starting maybe fiscal 18.
What will technically need to happen, council member, is that under your charter and your finances, any money that's not been appropriated must come to the city council to be appropriated when it comes in, and you will be able to direct it in any way the city council desires, based on a five-member vote.
Okay, and I get that. However, since we are addressing this growth expansion in business, we're not just addressing right now a 1% increment raise. We're talking about expanding this business altogether, allowing a business in the city. I think this is the opportunity and the time to have this discussion and to address policy.
And so what you're really doing is you're talking about a 1% increase. I'm holding this one up, a 1% increase in the business license tax, and then you're really talking about new revenue from your in lieu agreements on the adult uses. So you really are making two different allocations. Right? Because you get 1%, which we think is 300,000 to 500,000 on Chapter 21 business license tax,
okay.
And then the adult use sales, you're going to generate, I think, significantly more.
Right.
The staff report referenced millions of dollars.
Right. So this is just a small.
So okay, so
the
70
medicinal only.
So to clarify, 75E then is. So this is my question then, Madam City Attorney. Where would we address that larger revenue in lieu if it's not in the 75E?
It's actually going to be in the third item, which is coming back to you on November 21st.
Okay.
So November 21st, the staff will return with the merit-based criteria and the
Okay.
in lieu issues.
Right.
That policy
Okay.
decision will be
Makes
on the
sense.
21st. Today was just like a community workshop to get you delved into the details.
Okay, that clarifies.
Do you want to make a motion?
Would you like to make a
Councilman?
motion?
So, just to clarify then again, this 75, because since we have three items and we've been kind of going back and forth and studying them, frankly, it's gotten a little bit blurred, if you will. The 75E, does it address the broader uses and additional? No, this is the specific. Okay, okay. I then will go ahead and make the motion that
I'll second.
with 75E.
All those indicate by saying aye.
Aye.
You're taking action on 75E1, right?
Sorry,
E1, which is just
One.
the changes, just the changes. yes.
Language changes and a
Language changes,
1%
that's it.
increment.
Correct.
That's it, yes. Next,
And I'm fine with that, but there was a prior motion, a second on that, but I guess
was it already?
that can be withdrawn, and this would be the restated version.
What? I didn't actually end up.
I
okay.
I made a
Prior,
motion,
right.
and you second.
Did I second?
Yeah, you second, but you second the first time with comment.
Oh, I see what you did.
Yeah, and then you,
That's why it might be better just to
Yes,
withdraw
yes.
the first
Yes.
motion second and have this last motion second be the final.
Thank you for being a gentleman there.
75E2, now the next item is 75E2, which is an ordinance for second reading to adopt an ordinance amendment to create Chapter 40 in the San Municipal Code, which is the commercial cannabis.
I'll make a motion to approve.
Second. I do have just one,
We have a substitute motion.
one clarification point. One clarification point. I know during some earlier meetings, we had discussed for the manufacturing area what volatile solvents were and whether or not they could be used. And I know there was kind of, I thought, a consensus that really what those things are, which include things like butane and propane, which are common, that they should be fine. It would just be the appropriate building standards need to be in place to regulate that. And I didn't see your red line, so just if we can make that clarification. I reviewed the City of LA's ordinance, and they essentially acknowledge that even though that's the case, just as long as that there are appropriate building code items, that would be fine. So that's just that clarification from before.
I want to make sure I read those into the record.
Did you need a response from me on that? Yes, and
think you gave a response. You'll make the
OCFA is
clarification.
developing standards for regulating the manufacturing of cannabis.
With volatile.
So, safety standards.
Yeah, and I just want to mention that this is your second reading, but we have proposed to the second reading clarification language, which will allow the current medical cannabis business operators to apply for this RSP early, and which will allow the Director of Planning to give them a permit. So the changes we have for the record.
I'm sorry, a local preference, and also the other item would be to increase the number of retail from 23 to 30.
To 30, that's fine.
And Madam City Manager, I've made a motion. I think there's a second.
Yes, Councilman Benavides had a comment?
I do, actually. Thank you. So on with this one, it's a commercial use where we're talking about the all-encompassing, right? The retail, allowing for adult use retail and allowing for the other uses, cultivation, distribution, a number of others. The majority of our conversation here this afternoon has revolved around the retail, so that's what we're most familiar with. We have the dispensaries currently, and we're familiar with that. The other uses, frankly, there's a lot more complexity there. It's not something we've currently had within the city. Frankly, some of my colleagues have mentioned doing it right and going slow so that we do it right. I feel personally most comfortable by moving forward with the retail and allowing us to come back to some of those other uses. Because I think the main thing that the trigger with the state is the January 1 to be able to have the operational, which is what we do have right now, is the
Retail.
The dispensaries would allow us to go to the retail, the code enforcement funding that the state would make available. I still have a lot more question, and I think I'm not the only one. I'll leave it open to see what some of my other colleagues might have to say. But there's just, this is a whole new area, and there's a bit of discomfort.
If staff could respond to that, we're unclear what. Right now, we do have a ban on anything that has to do with adult use cannabis, right? We would like the opportunity, I believe, to move forward, but to not, to work harder on specifying on how we're going to regulate these, how we're going to be assessing them. But the issue for us on that January 1st ban is the state has been unclear on whether if you ban individual uses, whether or not you can go after the code enforcement grants. And you have that. Are you clear on that? Because we were not.
We will verify that. My understanding is that if you're going to allow any uses under the adult medical use, you would be eligible for grant funding. That's my understanding. I don't think the state's going to have different pools. Like, we have a pool of code enforcement manufacturing money. We have a pool of retail money.
We've had two different answers.
And the state's temporary as well.
That's my
so we're a little,
concern.
that we are concerned about.
It's in I think it's safer for us to go forward, because I've been hearing the same thing, that we're getting two different messages. And what if we get the wrong one? That's my only concern.
We don't have to issue. We are not compelled to issue the applications. To open.
Thank you, Candida. I know we have comments on Councilman Villegas.
I was just going to say thank you, Mayor Pro Tem. Just wanted to say that I agree with Councilmember Benavides, and we do need to take it a step at a time.
Great. Do we have a substitute motion?
So we do have a.
We have a first and a second on the original. So we would need a substitute.
Yeah, so then I would make substitute motion that we bifurcate and at this point move forward with the retail. However, with the caveat that there were a couple of questions with regard to having the permits go to temporary to coincide with the state, and then to allow for a regulatory permit similar to a regulatory fee similar to what we have with PrEP.
Yeah, and I don't mean to make this hard. I just need to be very clear about what you're thinking you're doing right now. E2, that ordinance, is a second reading of Chapter 40. Chapter 40 opens up adult uses in retail, manufacturing, cultivation, distribution. So
So rather than going to second reading, it's making these modifications and having it essentially go to a first with
No.
retail specific.
Right, so with the two changes that we offered, going from 20 to 30 and allowing RSPs on retail, we can make those changes on the second. What I'm not understanding is, if you approve this ordinance today, then you're approving
We're
manufacturing
not.
and cultivation.
There's a substitute motion on the table.
Okay, that's what I just want to make clear.
Right, but I have a question, because
I don't think that's
I
been
made a
approved.
motion on the first one.
But we have to
I know
do-
we have the substitute, but I want to be clearer. So if we don't vote on this ordinance as is right now, the substitute motion is strictly dealing with retail, the retail component.
Yeah, what I'm here...
So when's the second reading going to come back then?
No. So what I'm hearing right now is that the substitute motion is to take out of this ordinance the regulations that would permit manufacturing, cultivation, and distribution. That's what I'm hearing.
Okay.
And I'm trying to make sure I'm hearing that correctly, because that's significant.
Yeah, yes, that is
Yes.
the
I
intent.
agree.
My concern on that is, and I might be on the losing end on this one.
Right,
That's
can
okay.
is there even a second on it, or no?
Yeah, there is a second.
There is,
on it.
okay, there's a
Yeah.
second on the substitution, okay.
There is, right? Yeah. Okay, is that we talk about economic development, we talk about bringing revenue into the city, and this is just another level of slowing that down, where people right now could already start looking for property, investors can come start investing in the community. So that's the only reason that I would probably urge to go with the original plan.
And the, at least personal intent is to, yes, you're right, that it would be slowing it down a bit. I'm not saying at all indefinite. I would say even within a couple of months, at most 90 days, give us the opportunity to go ahead and hash through. That the urgency, again, is the January 1 on the retail. That we know, we've been, that one, we're confident we're doing well. We're doing it right. You know, the operators are being responsible, the city's enforcing correctly. So my motion is to, let's go ahead and give that the green light, let that move forward ASAP. Give us some time to be able to work out the others so that we can go ahead and bring those in as well, and just ensure that they're also, we've been thoughtful and we would be just as successful there as we have been with the
Well said.
dispensaries.
Agree.
Yeah, just,
Yes, Mr. City Manager, and then bring back to the dais.
We've not vetted this, so let me put that caveat out there before I propose this. One idea that we just discussed was we could probably put a caveat in this ordinance that all other uses other than residential, retail, other than retail, we won't open the period, we won't begin to intake any applications till May 1st. That would give us enough time to come up with criteria and deal with this, get our arms around this, which I'm sort of sensing we all are feeling uncomfortable with, without having to scrap this ordinance.
I could support that, Mr. City Manager.
Does that?
I could support that because in essence, that's what they're asking, is nothing's going to be issued until we have something in place.
I'm just trying to, the only reason you see all this hesitation is you're having a second reading of an ordinance that
Right.
you're just like taking pieces out. There's no way that I can draft here. I can do easy things like changing 20 to 30 and putting a definition in.
Right.
So if you wanted to do that, what you could do is have the second reading to remove those items and come back with the first reading on the 21st for those other items with specific timelines.
That would make sense.
You could do
I
that.
see that.
So then we start to work on so this ordinance would just be about retail, and on the 21st, we come to you with a first reading on the other stuff. That'll give us 2 additional weeks to work on more of it. And then at that time, if you want to put a date in that ordinance, once we give you that ordinance, you want to say it's not effective till May 21st or whatever that then we can do it. But to take this ordinance and say this section's effective now and this section's I can't do that for you.
Can't we just
You can
move
pull it out?
just pull out,
Yep.
and then we can discuss coming back. But just if we can, the intent, if we can today, move forward with retail based on the additional criteria that staff presented, and then the additional couple of comments with regard to the two.
To the rest of the stuff.
Yeah, there's two additional comments that were made. I'm sorry. Just the whole regulatory fee and the and the temporary. So just having, and if it's too confusing, we could just come back with first reading at the next meeting.
I'm trying to get as much as we can get done. I like you doing the retail,
So
so
first
we worked
reading-
really hard on that.
So then, okay, my motion is that we come back with a first reading at the next meeting to specifically address retail based on the feedback and input that you received.
To address
Retail specific.
Just retail.
If we do that, we will not make that January 1st.
You know, I've had my hand.
We have an effective ordinance on. We would not make the January 1st deadline.
I have my hand up. I have a couple related ideas, I think, to what I hear a consensus be. Well, one option is to try to split it down the middle and bring the others on the 21st. But I think sometimes it's not so easy to just cut a document down the middle and the retail is going to be perfect. That's my only worry. Another thought similar to what the city attorney said is maybe we just add language saying that the non-retail wouldn't be operative until the council approves the timeline for the in lieu fee agreement and criteria. So that we're really saying you can't move forward on applications, agreements, or anything until we approve that, and that's going to come back on November 21st. I just don't want to get it wrong, because also just legally, you know, we put things at rest to say we're assuming everything's going to be a nice clean tear, and it may not be, and it may put the whole thing in jeopardy.
That's been a big concern when we do that from up here. I think for the record, I think people need to know, staff went out and did this based upon the data and the information that they received from us at the Tuesday meeting. I have not talked to staff. They went at it and they've been working.
Right.
This was the first time I ever read it when I got here. So they've worked very hard. I don't think you can make, I think we still have to vote on the supplementary motion, on the substitute, but I would say, I would like to vote against that substitute and then go with what Councilman Solorio just said, to make it cleaner and easier for the public to understand where we're going forward, which in essence, it's the same thing.
Yeah.
It's just a different route.
I would like to just get some clarification from our staff. Excuse me, could I get some clarification on our staff on the substitute motion, what our options are? Because it seems like you all are also unclear. And we need to make sure that what we're doing, if we can do it or can't do it, so that we understand what we're voting on. I think what Councilman Benavides is indicating here in his substitute motion is that all he is moving forward with is the retail component, and with the caveat with the decisions that we made as pertains to the temporary permit, RSP permit, and also the possible regulatory fees for the PrEP program. If we can do that and wait on everything else.
And can we still make the deadline?
If we do that today.
As I understand the substitute motion with the second, you can do that with this ordinance. It will require us to take out all references to the manufacturing, distribution, et cetera.
Testing.
You will make the January deadline as to retail.
Right.
That's what we
Okay?
want.
Right.
And you would not meet the January deadline as to those other uses, manufacturing,
Yeah, that's
distribution, and
correct.
cultivation.
But I thought there was no deadline. I thought we already have a ban in place. So we
Right,
could
there's no, the
change
only
it
deadline,
later
I'm
on.
referring to the code enforcement grant money deadline, which
Oh,
none
the
of us
code
can give you a
enforcement.
clear answer on today, because we just don't know. I don't think the state knows.
Madam Secretary, what you just captured right now, that's precisely what.
Okay, so that's how I'm understanding the motion.
Yes. So we'll take the substitute. There's a first and a second. All those in favor indicate by saying aye.
Aye.
Yes.
Aye.
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 Great. Motion carries.
Yeah, I do just want to ask, just for clarification, the city attorney feels comfortable that that's legal and you could do it given the second reading status?
Yeah, because the second reading, you
got
didn't
it.
add, you
Got
took
it.
away.
Got it.
Yes, and we'll come back, we'll prepare the secondary version with all the other uses, because we'll just bring it back to you, and then you guys can work with the city manager as to when you want to do it and how.
And I want to speak really fast. And I think I heard that there's a potential of a 120-day extension from the state. If that's the case, then I think we have a timeline too where we can still get those funds. I just want to make sure we get those funds.
Right.
Okay.
So we do have one more item, which is 75E3, which is going to first reading, correct? Approve the in lieu fee agreement template with merit.
No.
That's the comeback.
That's to
Correct.
Right.
What we want
Make
to
a
do
motion to
here is
approve?
just hear your discussion.
Yes, it will come back. It's just discussion.
We're good.
Okay, fantastic. So this meeting is adjourned.
Progress.